everyone, and welcome to the Family Law panel, which is the first in the Explore the Bar webinar series. This series has been developed by the Committee for the Association of Gray's Inn Students and also the Education Department of Gray's Inn. And our aim in hosting these panels is to give students the opportunity to learn a bit more about different areas of law in practice from barristers who are currently practicing in those areas. And we felt it was particularly important to hold these webinars at this time, since we're very aware that one of the impacts of lockdown on students has been to reduce the opportunities that students have had to meet and talk with barristers through other means such as on mini pupillages. But that being said, moving things online has brought some benefits in that geographical restrictions are no longer an issue. And one of our panelists tonight is joining us from Manchester, and my co-chair is joining us from Cheshire East. Final thing before we begin, please do feel free to ask questions as we go along. If you can please submit them to the Q&A the Q&A feature rather than the chat box, and we will be answering those questions at the end. So without further ado, I'm Rosanna Corthwaite-Stern and I am the University of Law London representative on the AGIS committee.
Hi everyone, I'm Katie Goldstraw and I am the University of Law Manchester representative on the AGIS committee.
And our panellists for this evening are all members of Gray's Inn. We have Andrew Powell from Four Paper Buildings, Fazila Ismail from Harcourt Chambers, and Prudence Beaumont from Dean's Court Chambers. Panellists, to start us off, please could you share with us a short introduction to yourselves and to your practice? Andrew, if we can start with you.
Well, firstly, thank you for having me this evening. I was a bit perturbed when I received the invite to realise that I was the senior person on the panel, but there it is. 2008 call, I've obviously been at 4PB for Pupillage, and I got taken on, and my practice is predominantly, well, exclusively children work with a mixture of public law and private law children. I have a subspecialty in things like surrogacy and fertility law, as well as the international movement of children. So a fairly healthy and mixed practice. And this year I've been working on a fairly big public inquiry into historical and non-recent child sexual abuse. So as I say, a fairly mixed diary, and I've found working in lockdown challenging at times, but obviously grateful to have a job. There it is.
Thanks, Andrew. Prudence, if we can come to you next.
Hi, I'm again family barrister. Obviously, I practice from Manchester. I've been at Dean's Court since I did my pupillage. I practice in all areas of family law, so predominantly public law, but also private law and financial remedies. I was called in 2016, so still relatively junior, but yeah, really enjoying it so far.
Thank you. And Fazila.
Hi everybody, I'm probably the baby barrister of the group. So I just started tenancy in October. So I'm probably a fledgling barrister. Thank you, Andrew. So it's been a whirlwind, I think is probably the way to put it. So I'm London born and bred, and I did my undergraduate degree and bar school in Nottingham. And then I started pupillage at Harcourt Chambers in October 2019. Harcourt, they have two offices, so they're in London and in Oxford. So my practice is in London and the southeast. So I'm in London, Oxford, Reading, Swindon, those sorts of areas. I practice all areas of family law at the moment. In family law, you sort of do, it's a gateway into everything, as the panel will probably say as well. So you sort of do a little bit of everything until you perhaps specialise down the line, like Andrew has done. So I've had a variety of experience from being in person to having to transition to this lockdown life of being a barrister. So hopefully I can share that with you today.
Thanks, Fazila. Fazila, for those students who are relatively new to family law and don't know much about it in practice, can you just give us a brief overview of the main areas of family law?
So I think this is something that you don't realise how all encompassing it really is. So family law, it transcends into lots of different areas. You could have public proceedings, children proceedings. That's to do with the care proceedings where The local authority and social services are involved in a child's life, whether that's to remove a child into foster care. The ultimate imposition at the end of that is adoption. The other area is private child area, where family have separated and then they are trying to sort out the arrangements as to who the child will live with, who the child will spend time with, and how and when that contact will be. Some of the other areas are surrogacy that Andrew has mentioned that he works in as well. Other areas are talata, so that's the area of trust and land. That comes into the finance area. So when a husband and wife or a marriage separates and the marriage is ended, that's when there will be the financial area. So that's it. And the real variety of family law means that it requires so many different skills. So in care proceedings, if a baby or a child's been injured, you're looking at medical reports. In the financial area, you're looking at the bank accounts and asset schedules of a family's income and outcome of the marriage. So it really is quite diverse. And I think because it's so diverse, it means you can find your niche.
So let's move on to our first area, which is about your journeys to the bar. Katie, would you like to take us on?
Thank you. So the first question is, why did you decide to pursue a career in the family bar in family law? I'll go over to Andrew first.
It's a bit of an odd question, not a difficult question for me to answer because there's never really one explanation. I was always interested in working with people, so I knew I wanted to do an area of law where there's a human element. So employment, family, crime, immigration was what interested me. My undergraduate degree was in anthropology, and we did a lot of work on kinship and kind of Euro-American notions of what a family was. So that kind of also gave me an insight into family, what makes a family, and how the law and policy can shape what a family looks like. So when I was applying for pupillage, I actually applied to a lot of mixed sets. So I applied to a lot of common law sets. I did a bit of everything. And I only applied to a few family sets. And I applied to family to full PB specifically because I'd seen a case, or rather I'd written about a case in my undergraduate dissertation that somebody in full PB was in. So I knew of the chambers from that perspective. And I applied, as I say, to a number of chambers, and I got offered pupillage at full PB. So it meant that I basically became a family specialist from the get-go. And I think the one thing I would say is that family law sometimes has a bit of a reputation for being a bit of an underdog, or in this kind of hierarchy of perception of how people perceive family law. It's not often seen as being very glamorous, and frankly, sometimes it isn't very glamorous. But what I would say is that it's a real privilege to say that you're a family lawyer, because you're part of a process in which you're trying to find a solution for people who are at their wits' end, who are dealing with often the most distressing thing in their life. And, you know, as Fazila said, whether it's in a financial situation, whether it's a child that they haven't seen for a long time, or whether it's in fact the state being involved with that child, saying that child should be removed from you. So from that perspective, I think it's quite humbling to do the job that we do.
Prudence, is there anything you'd like to add to
that? Yes, similar to Andrew, I didn't do a law degree either. I read English, and then I actually did teach first, which is, I'm sure some people will be familiar with. It's a graduate programme teaching in schools in more deprived areas. So I too had a wider understanding of the concept of family. And I suppose the reality was I saw the children who I now represent and the families that I'm now involved with on a very human level, because I was teaching a lot of those children, or certainly some of them. There were quite a significant number within the school I was teaching that were involved in children's social care at varying levels. And so that sparked my interest. And again, my interest was human. I think that to be a family practitioner, that really is at the core of it. Lots of family practitioners joke that you've got to be quite nosy and you've got to quite like people. And that's the lighter point about the same concept, which is you have to be somebody who's interested in people and what makes them tick and what works for them, because reaching solutions for people relates almost entirely to understanding why they operate and what drives them. I think that it isn't always very glamorous, because you see people on the worst of days for them. It's interesting, I think, because when you start comparing practice areas, that financial proceedings sometimes seem, and certainly my view early on was significant, of less significance to the world at large, because they're not, the state's not intervening, but actually for those people it is just as important to them in that moment as the child being removed. Even if you on a spectrum say it's not as serious, get a grip, you're talking about 10 grand here. The interesting thing about family is that regardless of the case, it is their lives. And I think that is one of the things that is so fascinating about it as a practice area. And I think sets it apart from other practice areas, because I think that the really personal element to family is really one of the unique aspects of it. But no, I agree with much what Andrew said. It is definitely a people-focused area.
Okay, the next question we've actually got, and I think Fazila will really, really useful to answer this question. What was your experience of applying for pupillage?
So I think this is probably very different to anyone who was applying for pupillage this year with this lockdown and how that happened at all. The first time I considered applying for pupillage was my final year of university, and because that's when you can start putting in applications. And I really thought about what I wanted to make sure my application was at my highest when I applied for pupillage. I thought about the experience that I had, what gaps I had, and what I needed to improve upon. And I actually waited until I was doing the bar course the year later to apply for pupillage. My reason being was that, and I think that it was, for me, it worked out the best, is that when you are applying for pupillage, often you're asked to do mock exercises wherein you are, whether it's a bail application, plea and mitigation, whether it's a making submissions on contact arrangements, you're often asked to do one of these things in the pupillage interview. And because I was the BPTC course that I was doing, it was so heavily focused on advocacy. Every 2-3 times a week I was prepping and doing these exercises. So when it became time to do that in the interview, I was so well rehearsed because I was doing that each week, that it became a lot easier. And I think if I'd had the year after, if I'd applied for pupillage, it would have been, I may not have been as well practiced maybe. It was very, very difficult, and it was very, very stressful to balance applying for pupillage and doing exams and revising all at the same time. But I think for me that paid off in the end. One of the things I would say though, in terms of pupillage process, there are 2 elements to it: the written paper sift and then the interview side of it. When you're at the paper sift stage, you've really got to think about the person who's reading that application, and that was the best piece of advice I got when I was writing applications. I remember I drafted an application answers. I thought I'd perfected my answers and they were great, and I sent them to a barrister and he tore them apart. I think it's probably fair to say he red pen all over it. But the reason that, and what he said to me that stuck with me was, think about the person that's reading it. They are managing a busy caseload. Often they're going to be reading your application at 9-10 o'clock at night. You want to make it easy for them. And what that means is think about your structure. Make sure that your first sentence of that paragraph sets out exactly the skill that you are demonstrating. Think of that star structure, the situation, task, action, and result. That clearly demonstrates what that paragraph's trying to say to the reader. And I think I came from an English background at A-level thinking all this flowery language is going to really help you. But now when you're practicing, clear, simple language that puts your point across in a very concise way, that's what engages the reader, and that's what engages the court at the end of the day. And I think that's, and when I had been given that piece of advice, that really stuck with me, and it changed the way that I formulated my applications. So structure's the key one. The second thing I'd say is to do your application early, leave it for a few days and come back to it, because giving yourself that time, it really means that you can review it again with fresh eyes and see where all of the holes are. The one thing that I used to say as well is I had written, I was underpinned by a resilient work ethic. Too many words. You can simply just say, I work hard. And once I realized that, it really opened my mind, and I thought, why am I saying this? You really can just say, I work hard. And you don't have to go any further than that, because that's demonstrated through your academics. So it really is about pulling back, making your application very clear, very tailored, and that stands out against the background of what will be numerous applications that a chambers and persons reading it will read.
I think that's really good advice. Thank you. Just on that point then, the next question was, in fact, what advice would you give to someone applying for pupillage? So if we go back to Andrew, I wonder if you've got anything to add to that.
I think what Vasily just said about applications, and whoever advised you, that's exactly the advice I say. I was panicking thinking, gosh, was it me that said that? Because that's exactly what I say, that you've got to remember the person who's reading your application form probably has 30 or 40 other applications to read. It's been a long day, or it's the weekend and they're doing additional work. And so short, punchy documents are what you need, because the application form is a form of written advocacy, and that's your first step in the door, where you're saying to this person, persuading this person to pick me. And so as Vasily says, if you're using flowery language that might sound nice for an essay and beautiful prose, it's going to really annoy the reader. And so you've got to just be straightforward. The one thing I would also add is that, once you get in the door and you're being interviewed, and again, it's cliche, but I think it's true, is to be yourself, because the best thing you have to offer is you, because you are unique and there's nobody else like you. But there are loads of people who have got a first, a 2-1, who have done volunteering in X place, have done pro bono work here. Everyone has done that similar work, but you've got to somehow stand out. And so sometimes when you go to interviews, there are questions that are designed to, I think, to elicit more about you as a person. Because the other thing you have to remember is that when you're a pupil, I mean, I know it's a bit weird in lockdown, but in normal times, when you're a pupil, you're basically a shadow to your pupil supervisor for most of the day. And so you have to be able to convey something about you that says, this person, I could get along with this person. And then that's not to say it's not a personality test. I'm very clear to say that, because otherwise we'll end up with everybody looking exactly the same and who sound exactly the same. Obviously, that's not good for the bar. But what I mean to say is that you need to have somebody who you could envisage having a train journey back from court back to chambers, somebody who has the ability to talk about things. And so, those questions that say, tell us about a magazine you'd like to subscribe to for 12 months if you had a free subscription. That's not your opportunity to say, Family Law Quarterly or something. It's to say, actually, I'd probably subscribe to The Economist or Grazia or whatever, because, something that you can use to demonstrate a bit of your personality, and that there's more to you than law. Because at that stage, if you've got to the interview, you're ticking the boxes. So you need to add something to show what you're bringing to the table.
Thank you. Over to you, Prudence, if you've got anything else to add.
I mean, I agree with everything that's been said. I would add that in terms of the written application form, just because it says 250 words does not mean you need to write 250 words or 500 words. I think the points made about being concise and it being written advocacy are absolutely right. So don't feel you need to fill the space. The same is exactly true of the interview. Don't feel you need to fill the silence. I also think it's important to say that whilst it's easy to feel that there's a power dynamic, especially because we're all very aware of what the rates are for pupillage and how competitive it is, you are also, in a sense, interviewing them. If you go and you think to yourself, these are not my people, this is not the set for me, I don't like the way this is being conducted, then ultimately that's not the right place for you. And so much of it is not, as Andrew, it's not a personality fit, but it's about a sharing of values, an approach, that kind of thing that you're looking for. And you are likely to be the best version of yourself and feel at ease if you feel that it's a place that you see yourself being on a long-term basis. And strangely enough, those places are not always the places you think they're going to be. Sometimes you look at a website or you meet one barrister from a chambers and you think, oh, I wouldn't want to work there. They look awful. But that person, single person, may not be representative of the general vibe. And vice versa is true. You might meet somebody absolutely charming, and then you get to the panel and you think, these people are hideous. I don't want to be with in their company. So I think have a sense of confidence in your own self, and trust your instinct a little bit. If it doesn't feel right, probably isn't right for you. But yeah, I think but the comments made are absolutely right.
Brilliant, thank you. I'll hand back over to Rosanna for the next section.
Great, thank you, Katie. So moving on to your pupillage year, what was your experience of that? So some people do talk about pupillage as if it is going to be the hardest year of your life, and it probably will put you off law forever. Did you find that was the case? I mean, Fazila?
So I think the thing that I had to get my head around first was, especially in the care bundles, the bundles are massive. There were bundles that were 1,000, 2,000 pages. And when you start out, you have absolutely no idea where to start. You think you have to read from page 1 and read through. And it took me a long time to look at my supervisor, who was 20 years cool, who was able to get to grips with a case with a bundle that was 800 pages long. And so we have these, they're called case management hearings. So what they are interim hearings. So there's smaller hearings leading up to the final hearings. And I remember she had 5 of these hearings in the week. And that meant she had to get to grips with 5 different bundles that week. And I remember feeling, gosh, how am I meant to read every single page of this? What is this? And that was my first real, I didn't know what to do. And it's a skill that you continue developing now. And what you learn is that you learn the things of going back to the last order, seeing what the issues are for this hearing, going to the relevant documents, reading the relevant documents, whether that's the statements, whether it's the expert reports, and putting together your position statement or your skeleton argument, as it might also be called. So it's really trying to grapple with that and prepare for something. And I think to myself now, I did a case the other day and I think, gosh, Fazila, how did you manage to do that? Because when you started people, you had no idea how to navigate a bundle that was 1,000 pages long, and those things really surprise you. I think the people that are pupils in my year will have experienced as well the transition over lockdown. So we had this from October until March. I had this quite standard pupillage whereby I was shadowing different barristers. My supervisor was quite good at letting me go with different barristers, seeing their different approach and how they prepare and how that works. And then suddenly we were all thrown into this mad world of COVID. And at the time I was in Oxford. So at Harcourt, your second supervisor is an Oxford based or London based. So what that means is you experience both of the being in London circuit on the Southeastern circuit. So I was staying in Oxford at the time, and we were thrown into this chaos. On the Friday we'd done a hearing, and it was a 2-day hearing. So the next day was meant to be the Monday hearing, and the judge simply said, right, well, we're going to have the hearing somehow. We're going to have to do it on Skype for business. So that's what happened. And I think that family law had to react in this really pragmatic way, because it was a care case, and so we had to do something. The judge had to do something. There were decisions to be made on this case, and so they had to respond in this very pragmatic way. But I think what happened, so we had the hearing on Monday, but after that what happened is, and I'm sure that Prudence and Andrew will say the same, is that there was a sort of pause in the work, in that the courts closed. There was the work dried up, essentially down to a trickle, but really that was everybody adjusting. And it was only the emergency hearings that went through. So we were using Skype for Business, Teams, Zoom to try and do these hearings. And as a pupil, trying to navigate that, it's different when you're following your supervisor and you've got to push open the door and stand at the door. this time I was trying to navigate jumping between Teams or Zoom or which platform, and then the barrage of emails that are coming through. You don't want to be navigating that space of whether you say to your supervisor, can I have the link to join the hearing? All of those things, and whether you turn your camera on. So those are all things that I had to navigate as a pupil in lockdown, and that's something that nobody's really had to do. So we were all in the same boat, and I think the thing that I held on to was that my pupillage experience was very different to pupils before me. So because of that, I can't hold myself to the same or compare myself to the standard that they were. What I mean by that is I started on my feet on the 4th of April, but I didn't do my first case till the end of June. And so there was that delay, and it meant that I felt a little bit behind towards the end of my pupillage because I felt like I hadn't done enough cases. But you really do have to propel forward. And what's happened now, as I'm sure Prudence and Andrew will say, is that the workload has multiplied significantly. And now, whereas we would have done maybe 1 hearing a day, we're now asked to do 2 or 3 hearings a day. And sometimes that's the nature of how we're working now. I'm sure we'll touch on that as well. But in summary, my pupillage experience was one of a kind, I think.
Picking up on that, what does your working week look like now, Andrew?
I think the one thing I would say is I think as barristers, we're self-employed, and so you have a degree of autonomy about how your working week looks, but there is obviously always that element where it can be completely turned upside down. And I would say, I mean, I'm in a really weird stage at the moment because I've had a really intense, busy year, and so I'm not particularly busy at the moment by choice because I've elected to have my diary that way, so I've got a bit more control. But generally, I mean, outside of a normal year when I'm not doing inquiry work, my normal day is a mixture of either getting into chambers relatively early. I tend to get to the gym quite early, by about 6:30 or 7. I'm in chambers by 8, and then a lot of the work I do tends to be in central London, so I'm often in the High Court or the CFC. And so you're in court and perhaps until lunchtime, and then you're back in chambers, prepping for the next day. You might get sent to court again on something else if you're doing lots of like abduction work, for example. There'll be conferences with clients interspersed in that. And when you get to a certain, in fact, it's not even when you get to a certain stage. I think when you begin to develop a rapport with solicitors, and particularly if they're at a similar stage to you, you do get emails and queries from solicitors throughout the day. I mean, not every day, who will often say, have you got a quick 5 minutes to talk about X case? Because they want to run something by you and are possibly thinking about instructing you. And I can think of solicitors who instructed me, who went to court with me for my first non-molestation order in 2008 or 9, who are trainees who are now partners instructing me. And so you have that relationship where you can quickly where they text you and say, OMG, what is this? And you're like, let me find my red book. And so no day is the same, because there'll be days when I don't go to court. The thought, as Fazila just said, about having 5 CMHs in 1 week, it gives me a stroke at the thought of it, because I would much rather be doing a 5-day trial or a 10-day trial than doing 5 different hearings. Because as Fazila says, you have to kind of adjust and jump into different bundles and then do a position statement or discuss an argument for each hearing, and it becomes really stressful. So I fortunately haven't got, my practice isn't quite like that. And so it's a bit more, I've got a bit more control in terms of, because I do less care work. And so there's a bit more kind of flexibility in it. But what I would say is, what I'm trying to say is that there's no day is the same. And the one thing I am guilty of, and I'm often saying it to my friends and colleagues, that when you're quiet, you often say, make the most of it, have a, it's a Wednesday, like who normally gets Wednesday off? You go to the cinema or whatever, chill out, don't stress. And of course, when you have that yourself, you panic and you worry. And so you never really enjoy yourself. So there's always this kind of like sense of they're finding the right kind of medium for being busy. But it is quite nice that if you do try and respect that, when you do get those, a trial finishes early or it goes short, that you have a Tuesday afternoon off, and you can, well, in the normal world, you can perhaps do things, but not when you're in lockdown. So the message is no day is the same. And that's what actually makes it cool, because it's a bit of variety. There's no monotony of a 9-to-5 job. I mean, the sad reality is that we do work long hours. And I think I did a survey for Resolution recently, and it asked us what our Resolutions are the organisation for family law solicitors, but barristers can be associate members as well. I would recommend joining it if you're interested in family law. And I worked out that on average, at one point during lockdown, I was doing 15, 16-hour days, which is just, it's not tenable to be doing that consistently. And we've got to be careful about burnout rates. But the difficulty, I think, with lockdown has been, with what a normal day looks like, is that there's the omnipresence of email, and it's oppressive. Because when Fazila was talking about her day as a pupil, I think about my day as a pupil, in the other century, it feels like, in 2008, 2009, where I barely had a BlackBerry. Remember BlackBerries? So the emails weren't as crazy, whereas now it's constant. I had my first pupil last year, and we were talking about the differences, and I was saying, I never had this because we didn't really have, it wasn't that much of a need. Nobody really had smartphones, and so there wasn't this constant email checking at 8 p.m. or emailing people at 1 a.m. in the morning. So no day is the same, but it can be quite intense, and then you need to take time out when you get it.
Thanks, Andrew. Prudence, do you find the same, that it's quite difficult to strike a work-life balance? Is it possible to have a work-life balance when you're a barrister?
I think it's difficult. Wellbeing has become something which has had a bit more focus at the bar in recent years and months, and quite rightly too. I think it's difficult because I think there's some what I might call posturing that goes on, where people are competitive with one another about how hard they're working, how long it's taking them. And some of it is genuine hard work. You get periods that are just mad busy. And some of it is people just being utterly inefficient with their time and not having any boundaries. And I think technology doesn't help. I could be awful if I allowed myself to be, and I'm very aware of that. So I do things like I turn the email off on my phone, because then it doesn't, because I do not have the capacity to see an email and not respond to it or not think about it. And if you're in the middle of having supper with your friends or you're out with family, I think that's very disruptive. And actually you need to have a Saturday afternoon where you don't think about work. I don't think we're brilliantly good yet at sharing best practice. And part of that comes from us being self-employed and feeling a sense of autonomy about that, to the point where I think that most members of the bar would feel quite irritated if their clerks emailed them and said, why have you sent this to me? Or why have you filed this at 2 a.m? Because sometimes that's an active choice that people make. They've chosen to go out for dinner and to go to the theatre and to do it when they get in, either because that's how they want to do it, or they feel that's how they have to do it, or they might have just been quite disorganised. So there's a really fine balance, I think, between keeping checks and balances on people who are self-employed and then feeling irritated and restricted by that. My view is that has to come from us as a profession with one another, sharing best practice and saying, as I said, I turn the email off on my phone for a period of time so I'm not getting interrupted by emails. Somebody else says, I allocate an hour every day to go to the gym or to walk the dog or whatever it might be. I think there's quite a lot of work to do, and I think we're quite far behind other professions in that regard. I think it's particularly problematic. I sit on a couple of committees that are equality and diversity committees, and one particularly on the Northern Circuit, which is a women's forum, looking at retention of women, particularly in their 30s, because there is essentially a hemorrhaging of women who do not return after parental leave. And some of that comes, I think, and the statistics suggest, from a view that there is no work-life balance, and you cannot have it. And unless you're working every hour of the day, you can't be a good barrister. And we must change those attitudes, because otherwise we will lose lots of brilliant women, but also lots of brilliant men, because increasingly men take on lots of caring responsibilities, be that children or relatives or whatever else. So I think that it is possible, but I think it involves a lot of hard work. And I think there is a lot of work to be done as a profession to change the view that having a work-life balance is positive for your practice generally, rather than something that you sort of think you should do, but you don't really ever achieve. So yeah, some work to be done, but I don't think entirely impossible.
Thanks, Prudence. Going back to something Andrew was saying about building relationships with solicitors, Fazila, how have you found that as someone who is only recently got tenancy? Do you find that you're starting to build up those relationships with solicitors and you can sort of know where your work is coming from, or is every day a surprise?
So I think it depends on the person really, and I think for me, what I will do is when I get a brief come through in the bundle, I will email the solicitor, we'll set up a phone call, and then we'll talk about the case. And that really helps to discuss the issues that you and the solicitor are worried about. It also means that you get the solicitor used to who you are, because they'll all know that when I started on my feet, I was still a pupil, and I didn't try to hide that. I said, this isn't something I'm confident in. Let's talk about this issue and see what the pitfalls are of our case. Or, for example, when you're doing a fact find or a final hearing and you're looking at the case as a whole, it's helpful to discuss with your solicitor what the merits of the case are and where the weaker points are. So I think, and lockdown has somewhat helped with that, because it's meant that you don't have that travelling time. So there are little points during the day where you can bring solicitors and you can speak about the issues. And it means, especially for me, it's meant that they've got to know me as starting out as a barrister, and I've had repeat instructions on the back of that, because they've seen that the work that you've been able to do has been of a good quality, and that they think of you for another case. And I think that, as Andrew said, that propels, or hopefully that will propel through my career as well. And but every barrister works differently. Some barristers will take the brief, act on those instructions and move forward with that, and have minimal contact with a solicitor. And sometimes you just don't have you're so busy with the workload that if it's quite a straightforward case, it doesn't require a long chat with the solicitor. You may just do the case and then ring them afterwards and let them know how it went. It entirely depends on the barrister and depends on the case. For me, I think it's important that barristers and solicitors work together, because it's our case that we're putting forward for our client. And some barristers see it differently, and some barristers work in that way, and it really just depends for each case. And I think that it's important to value the difference is that solicitors have been working on this case for the weeks and preparing all of the paperwork. They know all the facts of the case inside out, and sometimes, as Andrew said, they'll ring you and discuss this legal issue that both of you aren't too sure about. So I had a case the other day where there was an issue of designation. So the issue there was a care order made, and which local authority is going to be is responsible for that. So both me and the solicitor were looking through the relevant provisions, trying to find the answer, and those sorts of things. They do help, because you're building that relationship with your solicitor, but you're also showing them that I can help on this. I can provide an opinion on this as well, and I think that's really beneficial. So it's that blend of the solicitor knowing the facts of the case really, really well, having worked on it, prepared all of that paperwork, and you coming in and you might see it from a different angle. You might notice something that's new on the case, and working together the way I see it to put the case forward.
Thanks, Fazila. Andrew, how do you feel that your practice has developed and changed over the years? And do you feel like you've been able to sort of guide the direction of your career and choose what areas you want to specialise in?
Such a good question. When I started, like Prudence, I was doing everything. So I did money, trust of land work, child protection, private law children work. I knew very early on that I did not like doing money work. I just didn't, my heart wasn't really in it. And it got to a stage where I wasn't doing it often enough to feel that I felt comfortable doing it. And so, depending on how your chambers operate, you have a conversation with your clerks, whether you have annual or kind of biannual kind of like appraisals, where I said, I don't think this is for me anymore. And I think early on, I knew I wanted to do things like surrogacy. And I think the biggest thing for me that helped open that kind of door was doing an Inner Temple Pegasus Scholarship in 2013, 2014. And Inner Temple do scholarships for all members of the bar. I think the cut-off point is under 5 years school or 6 years school, and they have some of the programs are pre-arranged. So you apply and you can go to Australia, you can go to Israel, you can go to Washington DC, or you can present your own plan. And I had done a few surrogacy cases by that point, by the 5 year point. And I approached a firm in Los Angeles that I knew of. In fact, that was on a case that I had been doing. And they said, yeah, sure, if you get a scholarship, sure, you can come and work for free for us. That'd be great. And so I got the scholarship and I went to LA in the beginning of 2014. I had to delay it for a case, but I went in 2014. And what happened was that I came back with a platform, having spent 3 to 4 months at a specialist fertility and surrogacy firm in LA, which then really propelled me into the surrogacy, fertility, alternative family work. And so there was an element, I suppose, of me actively seeking this out to develop my practice in this way. And I suppose, I'm really lucky that, I do cases that are really interesting. And I do things, things from radicalization cases to FGM cases in public law, to contact disputes where where the one parent wants to relocate to another country, to interesting cases where you're kind of at the forefront of how the law is changing and shaping how we think about what a family is. And a lot of that comes out through, as I say, through doing a couple of cases and then having a connection with solicitors and getting re-instructed. But a lot of the work that I've done that has been, super interesting, such as, for example, the TT case, which is a case about a trans man who gave birth to a child and wanted to be registered as the child's father. I did that case purely pro bono. I was being led by a Silk and another Chambers who specialises in public and admin law. We were both doing it pro bono, representing the Air Centre, who are a human rights charity who look at the interest of children. And doing pro bono work has been a really big door opener for other areas of work, because you do those cases and then you get instructions on another case that has similar facts. And so you do have an element of control, but I think you have to be clear about what you want to do, because there are people who are quite happy to do whatever they're assigned to. But I would say the majority of the work that's in my diary is work where people have asked me specifically, and it's not a case of oh, he's free, he's available. It's because they want me, because they know I've got a specialist interest in this work. So it's interesting how it's developed. And I think the one thing I would add to that, actually, before I finish on this point, is that if I was to look at my diary when I was at Cecilia's or Prudence's stage, the majority of my work was public law children work, so representing local authorities or parents, or rarely at that stage, or sometimes children in public law children proceedings. And it was round about 2014 when I went away to Los Angeles to do my Pegasus scholarship, where I saw the seesaw kind of change somewhat, and I was doing less public law work and doing more private law work and doing more kind of international work. And I think I got to a stage about a year or two ago where I thought to myself, actually, I miss doing the public law work. And actually the public law work is the work where you do, because if you're not doing a pupillage where you're doing crime, PI, employment, and you're kind of like cutting your teeth at everything, if we're doing a specialist family pupillage, doing public law children work is so important, because actually it grounds you in some of the basic skill sets you need to be a really good barrister. So dealing with cross-examination of witnesses in a care case sets you up for when you're in a private law dispute and you've got to cross-examine a child and adolescent psychiatrist. And I think it's really important to have a decent balance. I feel I've got to a stage where I've got quite a healthy mix of doing some public law work, some private law work, some pro bono work. And if you'd asked me, as I say, if you'd asked me 6 or 7 years ago, there was a point where I was thinking, I'm not really enjoying this job. And I was thinking of, applying to be parliamentary counsel. And thank goodness I didn't, because all I'd be doing is drafting Brexit bills, which would be quite frankly depressing and boring. So I think you get to a stage, you know, once you're over 10 years cool, where you've got a bit of autonomy and you can really shape it. And although it's hard, I enjoy it, and as I say, it's a real privilege.
Thank you, Andrew. I think it's time to move on to our last area before we hear some questions from our attendees. And this is on developments in family law and what's going on right now. So Katie, do you want to lead us here?
Yeah, thank you. Okay, so the first question is, how have family courts responded to COVID-19? I know, Fasila, you had an experience of this within your pupillage, if you want to discuss something like that.
So just building on what I'd said, and that the family courts had to respond in this really, really pragmatic way, because one of the differences between family law and other areas, perhaps like contract law or more corporate law, or in some ways the criminal law, that the harm's been done. So the shop's been robbed, the contract has been breached. The difference is in family law, it's forward focusing. The harm, if the child is still in the home, the harm is still present. And so family law has to look forward and find those solutions. And because of that, there's a sense of urgency, really, I think, and you have to be pragmatic about these things. And so my chambers, I think there was a couple of QCs in our chambers who were involved they were conducting this multi-day, multi-witnesses cross-examination on Zoom with the High Court judges on there. And that was the example that this can work, and it has to work, because really we are in a situation where you have to find an option, you have to do something to find your way through this. And so family law had to respond in this way. What we were using were Skype for Business, Microsoft Teams, Zoom. There's now a specialist court platform that they use for a lot of the hearings, and that it has varying degrees of success. And I think that some of the hearings you often find that you are, I once was cut out of a telephone conference 5 times, and the judge said to me, "Miss Ishmael, I think you should consider an alternative network provider." On the 5th time I was cut out. So varying degrees of success, but I think we've had to respond in this way. What it means in practice is that if you have 2 hearings in a day, I've done a hearing where I was in Oxford remotely in the morning, and then I was in Birmingham in the afternoon, and that's the reality of the job now, because it means that you can be, as we are all here, you can be in different places, so without that travel time. So the way that we change working is that, firstly, we're now attending remotely for the majority of the cases. It's only really, I've been to court a couple of times when it's the bigger hearings, the final hearings. So that's when the court are making the ultimate decision of whether the child's removed, or the contact arrangements, final contact arrangements, or if it may be that if it's witness examination and the parties don't have the technical capability, they will come to court and do that. I think that there is a concern because, as we touched on before, these are some of the most important decisions in people's lives. Whether their children stay or are removed from them, whether their child is adopted, those are really, really serious and important decisions. And for that to happen in somebody's living room, it feels really unsatisfactory. But more than that, they feel like they're a little bit jilted by the system if they don't feel like they're part of that system and part of that decision-making process. And there's a lot of power from a parent feeling like they're quite removed from that. And I think that's one thing that, as barristers, it's our job to make sure that our clients still feel like they're involved in that process. The way it's changed is that normally you'd meet your client on the day in court, and you would meet them, have a quick chat with them, and then go into the hearing. The way that my practice has changed is that I try and bring the clients the day before, so they're just a bit more reassured about who you are and what's going to happen tomorrow. It just means they can sleep a little bit better the night before the hearing. And those little things, they really make a difference for clients, because we've all been thrust into this strange new way of having to do these court hearings that are still very serious decisions being made, but the actual format of it doesn't feel that same way. It's the same sort of thing you would use to do a quiz with your friends, and and changing that importance is really, really difficult. And I think that, so the way we move forward with that is we've got to, we think about whether or not the courts are going to continue using this video platform. People have different views on this, and it may be that for some of the shorter hearings that don't require everybody to be in court, those can be done over the telephone, or those can be done over video. I think that it's right that the bigger hearings, the final decisions, that those are all in person in court, because especially when there are parents being involved with either there are learning difficulties or technological difficulties, it's important that they are there and they can be in that room with the judge who's making that decision. So I think that's where we are now, and to what extent we keep this remote way remains to be seen, but it's definitely changed everybody's practice. But for me, this is all I've known, so I've just had to do it.
Definitely, thank you. Prudence, how would you describe how the family courts have responded?
So it's my understanding that even at the height of the crisis, if I can call it that the family courts were still operating at 60%, which sounds like a big number, but obviously creates a huge backlog. But as Fazila said, emergency cases have to be heard because the risk is happening here and now. It can't be put off. So the family courts just got on with it. But I think it was different to different levels. So my experience was that in the High Court, it was relatively seamless, in part because actually quite a lot of hearings, especially if they're taking place outside of London, were taking place by way of video hearings in the High Court anyway. That wasn't unheard of. So I think they were more au fait with the technology. I think it's fair to say that as you went down in terms of seniority, things were more and more chaotic, and there was a heavy use in the early days of telephone hearings, and those were far from satisfactory because, particularly for emergency removal hearings, the idea that you've never met the client, you can't see them, you can't arrange a video conference because they don't have the technology, the local authority is applied to remove their child from their care. Understandably, they are distraught. The ability to comfort another human being that you've never met via the telephone on what is undoubtedly one of the worst days of their life is just far from being appropriate. So there were grave criticisms about that. So it worked when it was higher up, but at the bottom end, and I think with the greatest respect to magistrates and district judges and circuit judges, they were the ones who felt the pinch because they were so busy and they were dealing with those applications day in, day out, which are not applications which are being heard in the High Court. So I think the reality of it was not brilliant. Things have massively improved in that the general trend now, in my experience, is that most areas have got with the programme and are using video conferencing, which works brilliantly for case management hearings, when actually, quite frankly, it saves everybody travelling for what can be 20 minutes in and out, and then another hour driving home, which is entirely unnecessary. It's difficult for parents who, particularly in care proceedings, financially might struggle to get there. And it's difficult for parents who are working, who have got to take the time out of work and miss a whole day and have difficulties with that. So I think that's been a good improvement. I agree with what Cecilia says, that for serious matters, final hearings, evidence, lay parties who've got learning difficulties or cognitive difficulties, it needs to take place in person. And generally speaking, it is now. But I think a certain element of it is here to stay. Certainly the case management hearings, it now seems to me quite ludicrous that we ever went in person for those, because it is so straightforward to do it remotely. And those are things, and of course the civil jurisdiction has been doing telephone hearings for quite some time with no difficulties. So I think some aspects of it will definitely stay. But there are teething problems, and there are issues in terms of just assessing the demeanour of a witness via a video hearing, combined with somebody's dog barking in the background or whatever else, because that's the reality of people working from home. Their families are there. It's quite chaotic at times, and so I know you said about that kind of sense of professionalism when it's taking place in somebody's living room and the judge's dog's barked or something. You know, it's just far from being appropriate. So I think most of us are quite desperate to get back to court. I know that I am. I'd like to go and see some real people.
That's brilliant, thank you. Just in terms of like the family law developments, I don't suppose, Andrew, you've got anything to add when we say what recent cases, perhaps in the last year or so, should students be reading up on or looking at?
Gosh, I mean, it's interesting. I think whenever you get asked these questions, particularly if you get asked them in an interview setting, I would always advise trying to avoid the really obvious one that's been in the Supreme Court, because that will be the answer that 5 other people have given before you. The one thing I think that is probably relatively interesting, and I'm not sure how many people know about it. I mean, I've already mentioned the case of TT, the McConnell case that concerns the trans man and the issue about birth certificates. I suppose on a broader issue, what it does reveal is the issue about birth registration and how we look at what a family is, and looking at what a child's social reality is in terms of how that matches to their legal reality. The law, and I can talk about this for ages because I've been doing it for a while, but the Law Commission are currently looking at surrogacy law reform, and their programme of work, I think it was due to be published next year, but I think it's been delayed probably until 2022, and they're looking at how we can look at affording parenthood at an earlier stage. I think in terms of other cases, other than the TT case, which I think is a fascinating one because it involves 2 jurisdictions of the family division and administrative law in terms of judicial review. So the other areas that are particularly interesting are, all of these recent cases about COVID probably represent quite an interesting area of the development of the jurisprudence about how we look at hearings. I mean, I say that with a footnote, that probably is, those cases are probably the kind of cases where a lot of people would say them. So I guess be cautious if you're being asked in an interview whether you're going to roll off one of those cases. But I think a good tip, which I often say to mentees, is to go on to the chambers that you're looking at. And I know I'm kind of jumping into other questions that we've looked at earlier, but if you're applying for pupillage in a family set, go on their website, look at the cases that they've been doing recently, look at the ones that have been in the Court of Appeal and the Supreme Court, and look at those cases, read those cases. If it was in the Supreme Court, watch it online. I mean, it's a really easy thing that you can all be doing if you're struggling to get kind of work experience, or maybe pupillage is, because it's really difficult at the moment. But going on the Supreme Court website and looking at cases that are under the family law tag and watching them, you're ticking so many boxes because you're showing kind of like an insight and interest into the area, but you're also looking at the leaders in family law arguing their cases in front of Supreme Court justices. So without giving any more clues away, because I can't think of any other cases, because I've been doing an inquiry for the last pretty much 12 months. I've kind of de-skilled and about thinking about other areas of work that have been interesting. But go on Chambers' website, look at cases that they've all been in recently, and without being too kind of stalkerish, you can always weave those into interviews because it shows that you're interested.
Thank you for that. I think it really does show, these times are so uncertain that we just need to find ways to get experiences that maybe we wouldn't have beforehand. Fazila, how do you see family law developing in the next 5 years?
Oh, that's a really tricky question. In some ways, I feel like I've just touched my toe in the water of really what family law is, but I can see, I hope there are developments in terms of no fault divorce. So what that means is that at the moment you have to, that in order to get a divorce, it is under one of 5 grounds. There simply isn't a ground which is saying we just decided that we no longer want to be together. That's what the no fault divorce. It's not blaming anybody for the divorce. The most common ground used is unreasonable behaviour, and the no fault divorce seeks to it seeks to mean that there is nobody who is at fault and that the marriage is simply broken down. That's what I hope the direction of the family law travels in. Moving forward, I think that there are some developments in terms of witness examination where there are litigants in person and how we move forward with that. I think that how we work on whether video conferencing is here to stay and how that remains to be seen. It's probably not a question that I feel a little bit out of my depth to answer that one, as I think I've just stepped my toe in it, but that's my overall summary of where I think it's going.
Of course. Have either Prudence or Andrew got anything else to add?
It is a really difficult question,
yeah.
Because it involves crystal ball gazing, and so anything any of us say is completely a stab in the dark. I think Steve is right about no fault divorce. I think I defer to Andrew on this, but certainly developments in terms of surrogacy and how we consider the concept of family. There is, I think, to broaden the question and avoid answering it, always an interplay between policy and the law, and also what is happening in the real world. And so, and they seem to follow. So what people's actual experiences are of their lives and their understanding of how they see family, versus what policy says, versus what the law says, versus how we're implementing that in courts. I think quite an accessible example of that might be, and there were some reports at the end of last year, siblings. So most children who grow up in a family where it is made up of step siblings and half siblings and full siblings don't draw any distinctions. They see themselves as siblings. And I'm sure some people at this seminar today will be a sibling and have that kind of sibling group and make no difference between their half sibling and their step sibling and their full sibling. They're just siblings. But sometimes we're a bit slow, I think, within the law to recognise that and how we see that differently and how we put that into practice in terms of promoting sibling relationships, either when children are in care or when a child has been adopted with their other siblings who've either been adopted or haven't. For me, adoption is one of the areas I think is fascinating in terms of where we are in this country versus really the rest of the world in terms of a closed adoption where there really is still very limited opportunity for proper contact with family in a wider sense. I would suspect that there may be some movement in respect of that, but then that's what people were saying 10 or 15 years ago, and that hasn't happened. And so sometimes my perception is that change is very slow. Sometimes frustratingly so, sometimes appropriately slow because you need to take stock of the impact of any change. But I think more recognition of the reality of people's actual lives within cases and within public policy and then enshrined within law is where I would like to see things moving in the next 5 years.
Thanks very much, Prudence. I think we should move on to some of the questions that our attendees have submitted. So I have one here from Davina, and she's asking about the emotional aspects of a case, and is it bad to get too emotionally involved in the case, and how do you avoid this if a case does hit a bit too close to home? Fazila, would you be able to answer this for us?
So I think this is something that maybe because there's no separation really, is there? And I think that's something that we've dealt with even more working from home. You are dealing with some quite traumatic things that have happened to people, and you often think, gosh, you didn't realize that this happens, and having to face up to that or think that those things happen. I've noticed that Andrew said there's child sex abuse cases as well that covers as well. Those some really, really traumatic things that happen. And I think part of something that I struggle with is shutting your laptop and shutting your mind to those things that you've been dealing with on that day. That's a really difficult thing to do. And also building on what Prudence says, it's okay to say that's a difficult thing to do. It's okay to say, I'm actually really struggling with not thinking about this case. I'm actually really struggling with thinking with everything that happened in that case, and I'm now still thinking about it a week later, or I'm now waking up at 4 o'clock in the morning and I'm thinking about this thing that happened. Because there's and in some ways there's an expectation, and you've got to be a little bit robotic sometimes. You've got to have that barrier and move forward, and sometimes having a busy workload means that you do move forward and you do just keep moving forward with it. But I remember when I was going through this, I must have been about 15, 16 years old, and I'd gone to an event with the school, and we met the judge who was on the baby P case. And this was the case that there was some really serious abuse to a baby, and this is one that was in the news, and there were these pictures that came out, and the judge on that case had said he dealt with things, you know, horrible things day in, day out, but that case stuck with him, and he went home to his wife that night and he told her about it. And I remember thinking then, gosh, well, if that happens to judges, then it must happen to barristers. It's fine for it to happen to barristers as well. And that it may, and it's very difficult to do. Having that emotional resilience is very difficult to do. But I think that, as we've spoken about before, that human element of understanding why something is so serious to that person, why something affects them in that way, why for them it's such a heartbreaking and horrible thing, that helps you in your job. So whilst you've got to have that resilience and you've got to be able to step away from the facts and step away from the things, it does help you to be on a level with your clients. And I think that part of what attracts me to family law especially is not only are you engaging with barristers and judges on a really high intellectual level, but you also have to speak on a really normal human level with people who are your clients, who don't have the first clue about why they're here, what they're doing, what the law is, what, you know, they don't care about re T, whatever. They want to know what's happening for them and their family, and so it helps to have that emotional empathy with them. So it's a real balance, and one that I struggle with now and will struggle with, I'm sure, in years to come. So it's something you have to keep an eye on, and especially working from home where you don't have that separation of the chambers or a court, it's something you really do have to keep an eye on. And so I've started trying to put my laptop away, turning notifications off on my phone, only working in one place. Those sorts of things really help to try and have that separation, because ultimately, if you don't have that separation, it means that you aren't performing to the best of your ability, because you are too far into the case. So part of the reason why you are a barrister and you're not a counsellor or you're not a friend is because you are there to advise your client. What that means, and I say to my clients as well, sometimes I've got to tell you things that you don't want to hear, but that's my job. I've got to advise you of what a court's going to look at, what a court looks at this, what they're going to think, and having that separation to say, well, I understand why you might feel that way, and I really do. I appreciate all of that difficulty, but here's how a court are going to look at it. And it's not a nice thing that I'm going to be saying to you, but it's something I have to say to you. So you've got to think of those things when you're acting in your job, and try and keep that separation. But as I say, it's a hard thing to do.
There's a question here from this is a more general question actually, and it's more about for students who are at a slightly earlier stage of their studies and haven't yet decided whether they want to join, whether they want to go to the bar. And it's a question about how do you pick what inn you join. So this was probably quite a while ago now for some people, but and obviously we're going to be a bit biased because we're all Gray's Inn, so we've all decided that Gray's Inn is the place for us. But Andrew, how did you decide you wanted to join Gray's Inn over the others?
Well, of course, I completely agree with you, Rosanna. Of course, you know, there's only one inn to join. It's obviously Gray's Inn, and that's the end of what I'm going to say. The reason why I joined Gray's Inn, I had an A-level teacher who organised trips to London. I grew up in Birmingham, so I wasn't based in London, and every Christmas she took a group of kids down to London, and we would visit a bit of a legal tour. So we'd always go to Gray's Inn twice, you know, in Upper Six and Lower Six, and that was the inn I knew. So I joined in 2006, and even though I wasn't starting bar school until 2007, Gray's Inn was just the inn that I knew, and I'd done a mini pupillage with a barrister LA Criminal said, and he was also at Gray's Inn, and so it was a bit of a no-brainer. I mean, the one thing I would say, you know, putting obviously my plainly biased view to one side, is that it's really important to think about scholarships. And I can't talk about the other three inns, so I don't know what their scholarship approach is, but I do know what Gray's Inn approach is. But you need to look at the other inns and work out what, if you want to apply for a scholarship, work out what inn works best for you in terms of your circumstances, because some of the inns will interview everybody, some will do it on a means basis, and you really need to do your kind of due diligence to work out which one works for you. But the one thing I would say about Gray's Inn, putting the Gray's Inn hat back on, is that it's the smallest inn, which I think has loads of advantages to it, because it means that for me there was always a sense of home straight away, because there's fewer people, but it means you get to know people a bit quicker. And so I've always felt at home at Gray's Inn, whether I doing my dining sessions in 2007, 2008, and then going back, you know, a few years later, but I didn't really have any involvement. It felt like I was going back home again, and that sounds really corny, but it's true. And recently there was an education director called Quinn, who only recently has left. And you know, I can see Prudence and Zayla nodding sagely, because I know they probably know what I'm about to say. But Quinn interviewed me for a BBC, as it was called then, scholarship, 2007, whenever it was, along with a whole panel of silts and judges. And you know, Quinn, you know, maintained an interest in how I was doing all the way through, and it got to the point where, you know, then I was being asked to be on panels to interview people for scholarships. And there's this real kind of sense of, you know, we're all in it together and we've got your back kind of thing. So my personal plug for Gray's is that it's the inn that, for me, of course I can't compare it to any of the other inns, but there's a sense of being home, and that's why we always have a toast to Domus about where your home is. But I would say do your due diligence and look at things like scholarships and work out what works best for you.
If we just go to another question, this is actually from an anonymous attendee. Either of you can answer. Prior to your family law pupillage, how much did you know about the areas that are involved in family law? Because I know, you know, we don't get taught family law. So how much did you know? Prudence, if you'd like to start.
I think that is difficult, and I think that often people have a natural sway towards, particularly if they're interested in advocacy, crime, because it's easily accessible. You've read it in the news, and it's something that people understand. And part of the difficulty with family, of course, is that they are private proceedings and the access to them is more difficult. One of the useful things to do, I think, if you're looking to find out more, is do a bit of reading. So things like the Transparency Project is really good. It breaks things down really clearly and in a simple way. That project is all about, exactly as it says on the tin, looking at and understanding family law proceedings more clearly. Read the case law, but don't dive in with something that's overly complex. And start with summaries. I think summaries are a perfectly acceptable way to begin to understand a case. I know there was a point raised about looking up good case, and I think this is linked. You may find that a case is interesting to you because you read a summary of it and you think, oh, that sounds a bit interesting, and then you can read in a bit more detail, and that will likely lead you to another case and another case and another case, and the chain goes on because there's reference to other things. But there are lots of things that are not covered on the bar course or at undergraduate level. And so you do have to do a bit of research. And of course, the other answer is doing mini pupillages and finding out a bit more information through that route. And I appreciate at the moment that is much more easily said than done, because I appreciate that at the moment a lot of mini pupillages are not taking place. And if they are, you're not going to court and it's a bit more difficult. But yeah, do a bit of reading around it, and there's no one reputable source that you need to go to. But the case law itself is interesting. Attending talks like this, picking up on things that people have said, and think, oh well, okay, the Law Commission are looking at that, maybe I'll go and find out a little bit more about no fault divorce, for example, if that's something that's new to you, or surrogacy, or and you can dip your toe in it, and then if you want to, if you're interested, you can explore it a bit further. But I think mostly it's independent research, because I accept that it's not quite so readily available as other areas are.
Thanks, Prudence. This question's for Fazila. Matt is thanking you for the great advice on pupillage applications. And he also asks, how many sets did you apply to, and were they all family sets? Did you have a strategy when you were making your applications?
Thanks, Matt. I hope that some of my warbling is helpful to you. So I had a table, I had a spreadsheet. I applied to 36 sets in total. I applied to, I had 8 first round interviews, 5 second round interviews, and was offered pupillage at Harcourt. I applied to both family and common law sets. And this builds on the point of how do we get family law experience? And I think that now I look back, and I had got a single interview at a common law set, and the rest were family sets. And there's no real surprise as to why that was, because the majority of the minis that I had done were about family law. All of the knowledge that I had was about family law. And actually, to be quite frank, when I was in the interview for the common law set, the questions were more varied about the skills of being a barrister and not really tailored to family law. Reason being is because a common law barrister turns their hand to whatever case comes before them. It's a more varied set of skills that we're looking at. In terms of my tailored family applications, I've looked back at a few of them now, and the difference to me is clear. My family law pupillage applications were much more focused, because I could say, I understand this is an issue because I saw it in this mini pupillage, or I watched this documentary, or I read about this law, this case law. One of the other things you can do, and I fully recognise that it's so difficult to get mini pupillages, it really, really is, especially now. But remember what we said about family law being about people, about the issues. Think about how else you can tackle. So people say, oh, it's just about divorce, or it's just about children. How else can you look at that issue aside from it being a legal point of view? And when I thought about that, that's when I started volunteering for Citizens Advice there. And I hated talking on the phone, so it quelled that fear as well. So I had to build up my client handling skills of answering the phone. At least I had a patter of what I was going to say. Hello, Citizens Advice was my standard. But more than that, you are dealing with the issue, and you had to look at a person's circumstances, work out what the legal issues are surrounding it. But Citizens Advice don't give legal advice, but you can say you'd have to go to a solicitor to get some legal advice on it, but these might be a couple of the issues. And also other charities, the Gingerbread is the charity for single parents. There are also other parental alienation charities, different charities that you can get involved in. And if you join as a volunteer on their helpline, I have a friend who works on a domestic violence helpline. Those sorts of things, you're engaging with the issues, not necessarily in a legal way, but in a really practical way, and that helps to evidence your pupillage applications. And I look back now, and I think that's why my applications and interviews were strong for the family sets, because I could evidence those, because I could really demonstrate I know about the issues, and here's why I know about them, and here's why I think I'll be good at doing this job. So it's lining all of those things up, and I think that's something that it feels quite difficult to do at the start. You think, who am I to be saying I know anything about family law? I don't. But you recognise that, and you say, well, this is something that I've noticed is an issue, and it's something that barristers have to grapple with, and it's something that I want to improve upon and develop in my career as a barrister. I hope that somewhat answers the question.
That's really brilliant, thank you. Let's have a look at another question. What are the differences between the regional and the London bar? Can you move between them, for example? Andrew?
I guess I can only speak about the London bar because that's where I'm based. The one difference, the interesting point about that question is that even though I'm based in London, I do work outside of the Southeastern Circuit. And I think actually when I go outside of London, there's a bit more of a camaraderie. And so you go to places like Manchester, to Birmingham, which are massive centres, but there's much more of a sense of, and no one's ever, said, oh, you're the outsider, you're the London Council coming up. But there's a sense of like, everyone knows each other because the pool of people, there are fewer people compared to London, where I often go to court, I've never met the person before. I mean, it's a bit rarer now, so I'm a bit more senior. And so I think, I'm sure Prudence can probably tell us a bit more about what it's like, but one of the things that always strikes me, particularly at the junior end, purely from a kind of a commercial point of view, is that your cost of living in London is astronomical. And so if you're outside of London, your quality of life, I always think it seems to be a lot better. In London, again, in normal times, you're schlepping around on the tube, the bus, on your bike or whatever, and it always feels a bit more harassing. I suppose the one thing that lockdown has done is that it has fractured or broken down this perception of where you need to be, because frankly, it doesn't matter where you are, because it's going to be a remote hearing, it's likely to be a remote hearing at the moment. And so, there's a lot of, say, for example, international work involving child abduction. A lot of the barristers who specialise in that work are London-based barristers, and we're often instructed by firms that are based all over the country. But in actual fact, they could actually, because we're based in London and we're going across the road to the RCJ. But actually, if the hearing's going to be on MS Teams or on Zoom, then why don't they instruct somebody? I'm not saying don't instruct me, FYI, solicitors listening to this, but why don't they instruct somebody local to them in Manchester? Because they've got the same skill set. They don't need to be in London. In terms of the second part of the question about moving, it works both ways. I mean, I've seen people, friends as well as colleagues, who have left the London bar and moved to other areas for whatever reason. But equally, I also see sometimes people coming into London who have been in sets in other parts of the country, and they've moved to chambers, to us or to other chambers. So you can move around. I mean, the main thing is getting your foot in the door, getting pupillage, and then getting tenancy wherever, frankly. And it's not impossible and it's not unheard of. But it will be interesting to see what happens, I think, post-lockdown, because the need to be in a particular location, and as I think Prudence and Zayla said earlier, I think there will be a push for your interim hearings to be done via remote means, because you don't need to be schlepping, across London. But that's the other thing. I'm based in East London in Hackney, and it takes me an hour and a half to get to West London Family Court, which is basically Heathrow. And in the same time, I could cycle to Euston and probably get to Birmingham. So, if you're doing things online, it does mean that things might change and people might think, well, actually, do I really need to be in London? So I guess watch this space. I hope that kind of answers the question.
Prudence, would you like to add to that, your perspective from the circuits?
Well, I suppose collectively referring to them as circuits is problematic, because they are as different from one another as the Southeastern is. So I can only speak as someone who's on the Northern Circuit. My experience, of course, mirrors that of everyone else, in that I have obviously practiced on other circuits, including in London. My experience, particularly in terms of the difference between, so I practice in Stoke quite a bit as well, which is the Midland Circuit, and then in Cumbria, Lancashire, Manchester, and Merseyside. So most of those, apart from Stoke, are all on the Northern Circuit. So geographically, it's not necessarily any less travel. So I think that's important to know. If you are always in Manchester, and some barristers are more at one court centre than others, very few, but some are, then of course your travel is less. But generally speaking, you're spread across all of that area. So travel remains an issue, I think, whichever circuit you're on. Certainly, friends of mine who are on the Midland Circuit, that's a massive geographical area as well. So you can end up travelling a lot if you're there. There are some London council that I know that live on although they're changed in London, they practice predominantly on the Midlands circuit, particularly true of the Midlands circuit, I think more so of any other. So that's also a thing, slightly strange, but that's a thing that happens. But definitely my experience of being on the Northern circuit versus experience of when I've been in London, it's apparent to me when I'm outside of the Northern circuit, or true again also of the Midland circuit, that people don't know one another, and that is quite strange, because I would never go to court at the Central Court in Manchester and not see somebody that I knew. It just wouldn't happen, because although I'm quite junior, we all know each other. The value of that is twofold. One is it means if you bump into a solicitor, you know, it's a kind of automatic marketing tool, because you're there and they've seen you and then you're fresh in their mind. But also it's a friendship, and the job is really hard and it's emotionally very taxing. And part of the joy of it is that afterwards, particularly if something has been quite hard, you're able to say to your oppo, "Oh, that was a bit tough, wasn't it?" And it's someone that you know, and you can have a confidence of saying, "Let's go and get a coffee," or "Let's go and get something slightly stronger than a coffee." And there's something really nice about that. And there is a difference, I think, between, particularly true of London and the circuits, but there is much more sense of camaraderie. We know each other. Also, I think more so outside of our practice areas. So I know I have lots of friends who are criminal barristers and civil barristers who I see a lot of, because the other thing is that geographically we live close to each other if we all live in Manchester, whereas of course, you know, as has been identified, in London you can be travelling a couple of hours just to get in, you're still in London. That's not true of Manchester, even though it's a big city. That just isn't the case. So I think there's a stronger sense of circuit. Mess is much more of a thing for us up here. We definitely engage in mess. People go to it. It's, you know, people are from different practice areas. So that's true. And the cost of living, there's no London uplift for legal aid. So particularly if you're doing crime or legal aid family rates, it is what it is, and you're paid exactly the same whether you're in London or Manchester. So it's just maths that of course your quality of life will be better because the houses are cheaper here, the cost of living is cheaper here. So I mean, I would all be, you know, London has its merits, and I think it's important to say there are certain applications in certain areas of law which, quite frankly, you would not have the same quality of practice if you were not in London. That's just the harsh reality of it. But for most family areas of law, that isn't true, and it is much of a muchness. And you are doing just as many serious cases if you practice on the Northern Circuit as you would be if you were practicing elsewhere. So I've thoroughly enjoyed it, and I think I feel better supported on circuit than I would have felt had I been in London, perhaps. But again, I don't have a comparable experience.
Thanks, Prudence. Well, we are fast running out of time. So just to leave people with a bit of food for thought, can you each just very briefly say what is one thing that you wish you'd known when you were in bar school, when you were applying for pupillage? Fazila, can we start with you?
I think when I was going through this process, and I think this is, we also acknowledge this is a process that starts, well, for me, it was 10 years in the making, going down to courts and going down to the county court. And this was back when they had all the paper files. So I got stuck in one of those, you know, those winding files which they hold the files in. I got stuck in one of those. But this is a journey that starts way back over 10 years. And I think the one thing that I wish I would have known was that there are people like me at the bar. And that's something that I really, really think that's important, because when I was going through this, there was nobody really that I saw who looked like me, who spoke like me, who had the same experiences from me. I felt like I'd done a mini pupillage and was asked to be a poster girl for being the brown state school educated woman who was trying to be a barrister. And I thought to myself, family law impacts everybody. Family law doesn't impact one set of people. And because of that, it means that you have the skills to become a barrister, regardless of your background. there's not a one size fits all. And I wish someone had said that to me, that you don't have to be the barrister you see on TV to be a barrister. You don't have to fit that mold, as it were. There are skills that you have in your own individual self that come from your cultural background, that come from your school or your social circle, all of those things, which mean you can talk to people on a level that means they appreciate what you can bring to the table. And I think actually the best compliment I received was for somebody that said to me, Fazila, you're nothing like what I thought a barrister would be. But for me, that is a compliment, because it means that I'm changing the perception of what people think a barrister should be. It's not what they say on television, because, and for me, what's important is making the law accessible for our clients, for making them, as I said, we have to give them advice sometimes they don't want to hear, but they respect it because we're on a level with them. We understand them, and we know where they're coming from, and we know what they want to say to the court. And I think that's really important. So I remember I was doing I think I was marshalling a judge, and one of the barristers who was on the case was a Caribbean barrister who was from Trinidad, and my parents from Guyana in South America, so my background's Caribbean as well. And I remember when I watched her and as she opened her mouth and started speaking, that was like a light bulb. I thought, gosh, someone like me can do this job. I don't have to fit this mold or speak a certain way or pretend to be interested in something that I'm not. I can do this job. And it's building that confidence in you, which says that you don't have to be, if you're not this arrogant, competitive, or really tearing down somebody kind of barrister, if that's not who you are, don't try and be like that, because it won't come across authentic. Picking up on the points we spoke about earlier, be authentic, be yourself, because that's what you bring to the table. And I wish that somebody had really told me that really early on, because it changed the way that my pupillage applications were, my interviews were, and ultimately the kind of practice that I want to build.
Thanks, Fazila. Prudence?
I just want to say that I think what Fazila said is just so important. I completely endorse everything she said. I think that diversity at the bar is a massive issue. It remains an issue. I'm really saddened actually to hear that she felt that she didn't see people that looked like her, and we need diversity at the bar. It is for the benefit of all for it to be diverse, us as practitioners, but also our clients. So I entirely agree, there's real power in what she says. For me, I think that the key bit of advice that I would have liked to have received, and because I think I can be quite impatient, is that even people you don't think you're learning anything from, you are. Sometimes I think you go to court and somebody is being inefficient, or I might perceive them to be being inefficient, or they're presenting something in a way I think is not the right way to go about it, or they're being confrontational or aggressive, or any of those things that you think are not desirable characteristics. It's really easy, I think, to be dismissive of them just going about it the wrong way and take no notice of it. But certainly, for example, the difficult oppos being very aggressive unnecessarily, which Celia kind of gave an example of, and unfortunately that does happen. The learning point from that is not I should be more aggressive and more like this person, but the learning point is I can kill that with kindness, and I'm not going to rise to it. And I'm not going to be drawn into this nonsense, and I will remain a sense of integrity. And I think the temptation is, I think it's probably true, particularly when you're in your early 20s, to just think, oh, that's an awful way to behave, and that's dreadful. But you need to have a level of empathy and understanding for everybody, and you can learn from people's bad behaviour, and sometimes you learn more from that than from watching The Brilliant Advocate. I think certainly in pupillage and there's a turning point when you watch somebody in court and you think, that's such a weird way to have presented that. I wouldn't have done it like that. I think that's a real turning point. That's the point at which you realise you're ready to have a go yourself. Because the first few months you spend, I think, being in awe that anyone can stand up and do that and present it so well. But when you start to have that critical thought, think, that's an interesting way, I wouldn't have done it like that, or why didn't they say this? And you start analysing it, and there's real value in that. That's not to say you don't learn from watching brilliant advocacy, you absolutely do. But I think sometimes you actually learn more from the things that you would readily dismiss. So I suppose patience and realising that sometimes the best lessons are quite heavily disguised and they may not appear to be lessons at the time.
Thanks, Prudence. And finally, Andrew, one last piece of wisdom.
I would also endorse what Fazila said and also what Prudence has just said as well. Practical, you don't need a million mini pupillages to get pupillage. I mean, it's that simple. I did loads and I didn't need to do loads. You only need a couple. Like, you do not need to fill up your application form with, 10, 8, 9 mini pupillages. You just need a couple. And if you're interested in family law and you've done a couple of mini pupillages at 2 family sets, you're sorted. You don't need to get any more. And certainly, when I was in charge of mini pupillages in my chambers, if I saw somebody who already done 3 mini pupillages at 3 other family sets, or they'd done a lot of family experience, I would think to myself, well, actually, let's give it to somebody else who needs it a bit more. So do not feel you need to do loads of mini pupillages. That's what I wish I'd known.
Thank you, Andrew. Well, that's all we've got time for today. Andrew, Fazila, Prudence, thank you so much for giving up your time this evening and joining us tonight and sharing your wisdom and experiences. I'd also like to say thank you to the Gray's Inn Education Department, Tony, Daniel, Mary, and especially Nikki for making all of this happen. It just would not have happened without them. Our next panel is the criminal law panel on Tuesday, the 1st of December, same time. And our panelists for that will be Joel Benathan QC from Doughty Street Chambers, Oliver Kellum from 3 Temple Gardens, and Lowry Patterson from 30 Park Place. And I hope to see lots of people there. Thanks so much.